So hold on, let's do the technical thing before we start the whole discussion. So we make sure we can get comments, hopefully. So hold on. Let's start like officially at 8:05, but let's see if it's showing up everywhere where it should be showing up. Oh yeah, look, we are live, in fact.
Great.
Okay, so I'm just setting us to public, under our name so we can get comments. Let me test it.
Perfect.
Hold on, I'm going to test it. Oops, no, that's not the kind of comment I want to get.
Oh, nice.
Wait, can we see it?
Yeah, okay, people are starting to come in now.
Oh, perfect. Okay, this works. Okay, so we are live. All right, so let's do this. All right, so let me, since we are also streaming on your Facebook, let me do a brief introduction of me, and then we'll jump to you. So my name is Milana Dostanitch. I'm New York and New Jersey discrimination employment attorney. I mean, all employment law, really, discrimination, unpaid wages, stuff like that. Very passionate about making sure that the workplace is safe and fair, especially in times of coronavirus. And, I'm branching out into social media to bring other lawyers and information to people because, law is hardly accessible and I want the content to be digestible. So like awesome friends and colleagues like Avi have agreed to participate in this live series to talk about their part of employment, their part of law, so people can understand where they may have rights, where they don't know that they have rights. So that's where we're at. That's why we're doing this. That's why we're here. And tonight with me here is Avinoam Laby, right? Am I saying everything right?
Perfect. Thank you, Milana.
Okay, awesome. Well, so you're a malpractice, medical malpractice and personal injury attorney. You're a trial lawyer. I know that you kick butt because I've seen some results, right? So tell us more what you do.
So yeah, first of all, thank you for having me, Milana. It's an absolute pleasure. When you first asked me to come on, I thought it was a really good idea. A lot of people don't really understand and know when they have a case or not, and that's correct for, any type of law. For you, it's employment. For me, it's personal injury, medical malpractice. But, I really think it's important for us to kind of get out there and do, as best we can over the course of an hour, kind of explain different areas of law, and for me, it will be personal injury and medical malpractice. So my name, as you said, is Avinoam Laby. I'm an associate at Gersowitz, Libo, and Korek. We're a New York and New Jersey law firm, and I have experience with trials. I've experience with cases, from beginning through middle to end, and I'm happy to discuss with you and share, with the knowledge that I have.
Totally, this is awesome. I think I really appreciate how zealous you are about educating people in the public as well, because I think, if you don't know you have rights, you may never assert them. So it's very important to know where, in fact, you do have rights. So that's what we're doing here, demystifying all the legal jargon and trying to make it accessible, right? All right, so now, I know you're doing personal injury, medical malpractice. Even as a lawyer, I don't always think of them as the same area of law. How would you say, are they the same? Like, how do you practice both of them? And what's the gist of it? Like, when do we get into that?
So that's a really great question, a good way to start. First of all, personal injury and medical malpractice, while they sound very different and there are, nuances to them, both those areas kind of lie in what's called negligence. Now, I don't want to turn this into a boring legal discussion, but for us to start, just to talk about negligence, right? A lot of people have heard that word, on TV, or they hear, that I was wrong, that's negligence. People kind of think that automatically.
Right.
Those of us that went to law school, we know that negligence has specific elements that have to be met. Right. To bring a negligence case, right? And I know we joked around about this. Everyone that went to law school knows about duty, breach, causation, and damages. Those are the four key, topics in negligence, and both personal injury and medical malpractice fall under negligence.
Wait, hold on. Wait, let's break it down. So negligence is basically, as you said, and we'll go through the elements, right? So someone had a duty to act with some sort of care and they didn't. And as a result, you're injured. So I guess in personal injury, right? Like I'm thinking immediately like someone rear ends you or medical malpractice. I'm thinking like you had a surgery and it went badly. So is this the kind of thing? Is this what ties these together?
Right. So another great question. So there's negligence can fall under an umbrella of different types of areas. You can have things like the first thing that comes to mind, like you said, an automobile accident, a rear end, an intersection collision. You know, there's situations with what's called premises liability. That would be if someone slips and falls in a stairway in a building, slips and falls, you know, on a sidewalk going into a supermarket.
Right.
You know, there's also construction accidents. We represent a lot of construction workers.
Okay.
Under a specific, if a specific set of facts is present, you can actually sue while you're construction working.
Wait, but who is at fault if someone slips and falls in the staircase?
So that's a great question. It depends, you know, on the facts and the specific situation that you're talking about.
Yeah.
But you know, generally, if you slip and fall on the sidewalk in New York City, you know, potentially the city could be at fault. Potentially any construction company doing work in the area under the ground could potentially be at fault. Also, building owners in New York City are responsible for the sidewalk abutting their property. So potentially they could also be at fault in a situation like that.
Right. So they're responsible. So all those actors are responsible to keep the sidewalk safe, the staircase safe for you. And so if they were potentially...
Exactly. The important word is potential. Every fact is different. You know, no client that comes to us has the same story. Every single situation, every single accident, so to speak, has its own moving parts. So potentially, yes, those are all the potential, you know, entities who could be at fault.
Okay.
Some more examples. It could be a physical or sexual abuse situation where something like a priest or a rabbi, you know, has a duty to protect people, but instead, you know, wrongs them in a way like that. That's also negligent. Additionally,
but who's negligent there? Like the church or the religious establishment?
Right. Potentially, again, depending on the situation, it could be where the church, the synagogue, you know, the mosque knew about this behavior, didn't do anything about it, or, you know, didn't know because they kind of turned a blind eye to it and should have known. You know,
right.
That's another potential, you know,
very interesting
situation.
So it sounds like to me, honestly, you know, that it could happen almost anywhere. Like, I mean, negligence seems to span so many different situations, which is, you know, so interesting. Again, like I'm a lawyer, right? And I think personal injury, I think of like two very, you know, narrowed scenarios. And I don't even know, you know, sometimes, you know, I don't even think about it. So it's very interesting that you're giving such a breadth of examples to know that, you know, people perhaps should call for a consultation there. All right. So I won't interrupt you with more questions. Please tell us.
I want you to ask as many questions as you can. And everyone else, if you have a question, you know, feel free to ask me. I'm happy. You know, the whole point of this is for me to answer questions. So I appreciate that. Just to give you a couple more random examples, there's situations where, you know, boat accidents, either cruise line, someone slipping on a cruise, and you're in international waters, you know, a situation like that. Two boats out in the marina, you know, in Long Island, colliding into each other, that you know, all those things. Bike accidents, bicycles, e-bikes, motorcycles.
Right.
It's examples of potential negligence and types of cases which is what we deal with, could literally.
All right. So how do we know if we're the ones at fault or if we're the ones that actually have a case against them? So like, what are the things you look for? Like a client comes to you, how in your, you know, trained legal mind do you start this analysis?
So that's something where you really have to investigate and really ask the right questions when speaking to a potential client. It's very important to remember you're meeting the clients on their worst day. The day that they contact a personal injury attorney is literally the worst day, either for them or for one of their loved ones or for someone in their family. So,
right.
You know, you always got to keep that in mind, especially in this field. So just to clarify, like you said, you need to meet the elements of duty, breach, causation, and damages.
And those are the legal elements you have to meet to have a case.
I'll just give you a quick explanation. You know, for For a duty to be present, that means that someone owes a duty under the injured party, right? So example could be a homeowner. If you invite someone over to your home, you're under a duty to make sure the entranceway to your home is safe. It isn't too dark or it isn't slippery or something like that.
Hey, hold on, Avi. Actually broke up. I didn't hear your definition of duty, and I don't know if everyone else heard. What's the definition of duty?
So where the defendant owes a duty to behave in a certain way or to do or not do certain things to the potential plaintiff or injured party in this case.
Okay.
So an example of that is when you're having someone over your home. An example of that is when you get in your car, you're under a duty to follow the rules of the road. To stop at a stop sign, you know what I mean? To stop at a red light, to not make a red light until you have the green, things like that. So that's duty.
So it sounds like, I mean, obviously, I know that in case law, duty for different situation may be defined, but it sounds like when we're talking about duty, it's like something that a lay person would assume keeps the society safe. You have a duty to follow the red lights. You have a duty to not harm people that come onto your property, like the mailman or whatever. So it's like this kind of duty to act within reasonable standard as as a quote unquote reasonable person, right? That's what we're talking about.
Exactly. Generally, it's to act reasonably under the circumstances. But right, every situation is different, but that's correct. And duties being under a duty to do or not do something is all around us constantly. We don't even realize, how many times we're actually acting according to either our legal or, common law duty to do or not do something.
I see. Well, we actually have a question about that, which says,
sure.
This is pretty detailed. Does MTA have a duty to a passenger attacked by a homeless person?
So that's a great question. I would need to know a little bit more, but as a common carrier, the MTA, the Metropolitan Transit Authority, does have a duty for people buying tickets from them, right? They're making money from people, taking them around in trains, buses, subways, whatever it is. Mm-hmm. Under specific circumstances, there could be a duty on the MTA to keep the premises and the trains safe from homeless people. With MTA, a lot of the cases that we work with in our firm is, unfortunately, you see a lot of people being hit by subways. So,
oh, no.
So that's an example of, if for whatever reason it happened or, there's situations where there are fights on a subway. So, if you can prove that MTA knew about this and didn't do something to correct it to make it safe for the passenger, there could potentially be a duty in that situation. That's a great question.
That's interesting. Yeah. So when, you say this, I remember reading these posters and being terrified. It was 149 passengers in New York City in 2018 were hit by trains. Don't stand next to the platform. I literally stand in the middle of a platform because of this thing. So, okay, that's good. That's a good question and a good answer.
The numbers are horrifying. You're absolutely correct. The amount of people the amount of accidents that occur are really, it's heartbreaking to see.
Right. Okay, so we have a duty. So basically there is this duty in different areas that, people or a carrier or a business have to make things reasonably safe and act reasonably. Okay, so what's the next?
It's literally even a driver is under the duty to stop at a red light, to not hit the car in front of them, right? So duty is all around, like I said. Next, the second element, you need a breach of that duty. You need someone to either act in a certain way or fail to act in a certain way.
Interesting.
In contradiction of the duty that they had. So if you're if you're running through a red light in an intersection and you hit a pedestrian who's lawfully in the crosswalk with the walk sign to cross, you breach your duty to yield to the right of way of a pedestrian. This is one of the most common ones that people know.
Right.
So in that situation, there was a duty on that driver, and the driver breached their duty by failing to stop at the stoplight.
Interesting. Okay. So
it could be anything from a supermarket, breaching their duty of keeping the sidewalk clear of debris, for example. Right. We have cases where people slip and fall on things, right? On uneven sidewalks, on uneven sidewalk flags. So that's a breach right there. They didn't keep the sidewalk even and flat and, safe for those people coming into their business, for them to make money.
Yeah, this is interesting. I was actually, I think I remember in law school or whatever, I got like a friend who was like in Cipriani's or something, and there was a broken glass, and they told that there was a broken glass, and it was like a wine glass that had a stem, and nobody cleaned it for like 30 minutes, and finally, like a friend of a friend fell and like cut her entire arm open with nerve damage, and it was awful. And I remember this conversation saying Cipriani's had a duty to remove the glass before the dancers on the floor this happened to. And so this sounds like it, right?
And yeah, the most important part of what you just said is that they complained to someone at Cipriani. Cipriani knew that it's there. What you get in a lot of the cases, the defendant, in your situation, Cipriani would say, "We had no idea it was there. How are you going to blame us for that?"
Right.
It's the people that were eating dinner. It's their fault for breaking the glass, for falling on it. That's what the other side says many times.
It doesn't matter if they knew, if they should have known. Is there like a standard, like you should have known?
It's knew or should have known. And if you're going to argue should have known, you have to have a strong argument of, policies, for example, of where they train their waiters. I'm just making up an example.
Yeah.
Where they train their waiters, as soon as there's something dangerous, the waiters are trained to immediately get rid of it or clean it or make it safe.
Yeah. Okay, so I have to make a confession. I think I've been taking away business from personal injury law firms for at least the last 6 years, because if I ever see a drink spilled on a dance floor, knowing how dangerous it is, I'm like the one who's like knocking on kitchen doors, being like, clean it, clean it, clean it. I guess if I hadn't, no, I'm kidding. I regret nothing. In terms of helping people.
That's why we're doing this, so people like you and everybody else, can have a better understanding of what.
Yeah, absolutely. I mean, we are here to talk about it when it did go wrong. How do we get help or compensation with whatever medical bills, distress, and all of that, right? All right. So we had the duty. Then someone breached it. So they did do something bad, or they didn't do what they were supposed to do. And then what else? What's the next one?
The final two that kind of go together. It's causation and damages.
Okay.
Meaning that the duty and the breach of that duty caused damages or injuries, right?
Okay.
So causation would be an example of either an action or inaction that actually caused the injury, which would be the damages. And the damages have to be that the plaintiff was actually harmed or injured.
Okay. All right. So we understand that, right? So you crossed the red light and that caused someone else to have a broken rib.
Right. The common example of this is you have two cars colliding in an intersection.
Okay.
Car A and car B. The driver in car B dies, but they don't die from the collision and the impact. They had a heart attack 10 seconds before. So you have all the elements, but you don't have causation in that situation because the person what caused their injury is actually something else. So that's just a general example where you're missing causation. For that reason, it's most likely not a negligence case. Interesting.
Okay, hold on. We have a question which says, what if I'm partially at fault for my injury?
So that's another great question. There is what's called comparative fault. So every state does this differently, but in New York, you could have a jury verdict of out of 100%, 60% against you, 40% against the other party, 30% against you, 70% against the other party.
So you mean is like, let's say this person, they acted negligently themselves, but yet they didn't fully cause their accident. So I 30% am responsible, but you're 70% responsible for.
Yeah, you see that a lot in car accidents and trip and fall cases. A lot of times, this is assuming it goes to a jury. A lot of times, a jury will say we feel bad for this person, but also. Maybe they should have seen that little, so we're not 100% faulting either side. We're going to split it 50-50 or split it 60-40.
Interesting. Okay, so wait.
That's a specific situation if the judge doesn't before that decide, because a judge could decide through what's called a motion for summary judgment that it's 100% on one side or the other. So it's kind of a nuanced answer. It's not always black or white, but there are instances where it could be not 100% your fault, but you're still entitled to compensation.
But I think what we can take away from this is that even if you think you should have known better, or you should have acted better, you should not hesitate to get a consultation, because even if you partially were involved in it, you could still have a case, right?
Absolutely correct. You know, we have cases, you know, someone crossing the street in the middle of the night with no crosswalk, and they get struck by a motor vehicle. That's the case that we're working on. You know, we represent that person.
Okay.
You know, is there a possibility that fault could go one way or the other? Of course, but as you said, even if you think there's a chance you're at fault, it's still very important to contact an attorney so they can look at the specific facts of exactly what happened. Exactly.
Totally. You know, and I say this, you know why I say this? Because in my own practice, so like in employment law, sometimes we'll have like a sexual harassment cases or discrimination cases saying, if only I was better, if only I was less something or more something, it was my fault. And so people like self-blame and then sit on their claims and don't realize that all along, the little fault maybe or may not have been there doesn't invalidate their case, right? So it sounds like in this area of law too, like, yeah, sure, you may have contributed to the issue, but that still could mean you still have a valid case, so you shouldn't automatically discount it if you're like, quote unquote, a little bit like, you know, should have done a little better, right?
Exactly. And ultimately, the judge, and in some cases the jury, are the ones that decide that. So even if you yourself think, you know, I'm at fault for this, that's not necessarily the case.
I think that's a really good point we uncovered. I think that's really important to know. Honestly, I love it when we uncover like stuff that, you know, you should know, but I don't think it's common knowledge. So,
you know, even I just had this happen the other day, you know, even two bicyclists colliding with each other.
Okay.
Even that could be a case. You know what I mean? I had a friend of mine, you know, he was in a bicycle, he was riding a bicycle, he got hit by another biker. It was some, you know, young kid. And, you know, he figured there's nothing here. I'm okay. The kid drove off, and turns out he has a fractured elbow and needs surgery.
Oh no.
So and he's like, he said to me, you know, honestly, I probably should have slowed down or whatever. And I said, I wish you would have gotten the kid's information, and I wish you would have called me sooner. So that's,
you know, yeah. I mean, I've heard that before too. You know, I had someone who was a professional musician, like with a full-on career, that had some sort of like either bicycle or car accident, I don't remember. And at the moment they were fine, they're like, okay, fine, go. And then when the shock wore off, it turns out like the hand they play with was like damaged. And then they needed like physical therapy for like 3 to 6 months, lost a bunch of income and stuff like that. And they didn't know who the other person was, because they were like, oh, I'm fine, it's just a scrape, but it wasn't. And because they're like a high paid professional musician, they were actually out of a lot of money and needed a lot of rehabilitation that was very specific, and it was no luck, you know. So it's a good idea to obviously know the information anyway, right? And then you will see how you feel after, because there is that like moment of shock and not knowing what's going on.
Yeah, that's a perfect example. One of the things you can ask a jury for is what's called lost wages. So what happens under that situation is, you know, we ourselves in the court actually look at the tax returns, how much money someone made in the past, what the projections are for the future. And in your situation, you know, if it's a famous musician or something like that with, you know, with tours booked for the next year that they had to cancel, and showing proof of that, lost wages is one of the things that an injured party can be compensated for.
So wait, that's part of the damages, right?
That's correct.
Wait, hold on. We have like so many questions, which just makes me so happy.
Great, yeah.
People are watching.
Thank you guys for asking. We appreciate it.
Wait, can you see them or no?
I see a couple of them, but they keep disappearing from me. But you keep firing them away.
Yeah, I can see it. I think I can actually drag them on the screen, but I'm not going to try. Okay, what determines how much I would receive after a verdict, and how much does that my attorney get? Wait, hold on. We're definitely going to get there. But what factors do you consider when deciding whether or not to take a case?
Okay, so that's another great question. So the 4 elements that we discussed, just generally, right, when you hear about what's going on, you speak to the person, the lawyer, you know, we're doing a quick calculation in our head, those things have to be present. Right? Next is you have to have someone to sue, and most times you have to have insurance coverage. Not always, but most times you want to have insurance coverage, because what happens is this is another thing that a lot of people don't realize is when you sue someone, most times if there's an insurance company, if there's an insurance policy that you're suing under, the insurance company pays for the attorney The insurance company gets to act as if they're the person during the case.
Interesting.
But it's actually the insurance company because you're going after the insurance policy in most cases.
Right.
There are cases where you can sue a person or a company that either don't have insurance or your injury is worth more than the insurance coverage. So a big thing is there has to be available compensation. If unfortunately,
pockets. You mean pockets?
Right, there has to be someone, and that's the reason people get insurance, right? The whole point of the insurance industry is for situations that we're talking about. So if someone is a victim of negligence, or if someone that they're insured, is a perpetrator of negligence, that they will pay for that. Now they fight you for it, and most times you have to go years through discovery and a trial to get there. But the next important thing to have a real case is to make sure that there is either an insurance policy or some sort of compensation even available out there, because otherwise it's a fool's rush, right?
Interesting. So wait, hold on. So, but is it like today I got hit by like a random bicycle, motorboat, I don't know what. Do I have to know, or will you tell me as an attorney? Will you check?
Absolutely. We have a lot of ways of figuring that out. And, for example, in a car accident situation, a lot of times the insurance company is going to be on the police report because people have their registration papers.
Okay.
What we do is basically if the potential case meets the 4 criteria of negligence and there's a real injury there, because different law firms specialize in different types of injuries.
Sure.
The firm I'm at, Gersowitz, Libo, and Korek, we specialize in catastrophic injuries. So
like very serious stuff.
Very, death, dismemberment, disfigurement, surgery, fractures, things along that line. And a lot of times that's not there right away. You hear about a pedestrian hit by a car and they say, I'm fine, I walked away, but honestly, this car hit me in the middle of the sidewalk. You don't know how many times, like we said, it takes a month, 2 months, 3 months for that person to realize, oh, I actually tore something in my knee, I need surgery. Or,
that's right.
I have a little fracture, but I need surgery. I'm going to be out of work for 4 weeks. And I'm going to be doing physical therapy for the next 6 months.
Now that you say you're what you specialize in, it really brings home what you said in the beginning of this video, which was, you meet them on their worst day, right? Because the injuries we're talking about here are pretty significant, and meeting someone like you obviously would make them better, but they would never make them better. It would at least compensate or help heal or recover.
I've been to the hospital with someone after they fell off a roof. I've been in the hospital meeting with clients after being in a motorcycle accident. And literally lying in bed on respirator, on life support. I mean, it's
oh my God.
Yeah, it gives you an appreciation for life. You know what I mean?
We must have like a sort of like not thicker skin, but I mean, you must have both compassion, I'm assuming, right, and a way to process it and comfort them with law or knowledge or whatever it is, right? All of those
Definitely.
things.
But the flip side is that is I'm constantly, and I know my other attorneys that work in this field, I've spoken to them about this. You're constantly thinking of what can go wrong when you're in my field.
Yeah.
The craziest examples. I mean, I'm talking about a brick falling from the roof out of nowhere and in the middle of New York. You know what I mean? A dump truck, running over a pedestrian just crossing the street, things like that. An Uber driver, plowing through people, things like that.
That's terrible. Yeah, I mean, on a lighter note, right, like to take it out from the really serious, important human note, but I've been living in my building for 6 years, and above our entrance door is all the ACs, which is 5 floors, so it's 5 ACs. Every single day that I walk into my door, I look up and I say, is this today you fall on me?
Right.
I mean, I'm kidding, but,
no,
but yeah.
I know it's a joke, but we've had a case of I've seen it come through of an AC unit, falling on people. Unfortunately, something that happens. In that situation, I'd recommend, telling your management, this is unsafe. I don't feel safe. Looks like it's going to fall. Telling your super, telling your doorman, whoever it is.
Right. Okay, so let's get back to where we're going. I think so we did start to talk about damages, and I think we had a question about that, which we'll talk about, I'm sure, verdicts and stuff. But we have another question, which is, Okay. Can you represent a person who's not a citizen of the U.S. in their case? Is their case disqualified because of their immigration status?
So that's another great question. The answer to that is no. We represent people of all different ethnicities, all different religions, all different citizenships. That does not matter. We have plenty of clients who are either in the U.S. on business, U.S. in New York on vacation, and immigrants, both documented and undocumented. So they're it could be a potential point for the other side to try to poke through our case, but we will still represent you even though you're not an immigrant.
That's really, really great. I mean, that's really great. That means if something bad happened, you shouldn't, keep quiet. You should.
Yeah, I think there's some misinformation out there. A lot of people think that if you're not a citizen, that you can't bring a suit, and that's incorrect.
I mean, the same thing in employment law, right? Like I have undocumented workers that work the hardest, like 7 days a week, 80-hour weeks for 20 years. And they're like, I have no rights. I'm undocumented. My employer has told me this, that undocumented workers have no rights. And they do have rights. But, it benefits the perpetrator to say that you have no rights, right? So it makes me very happy that you also can take anyone as your client.
Yeah, it's like I said, it's important to understand that as personal injury and medical malpractice attorneys, what we do is advocate for injured people basically against insurance companies. So there's a big insurance company lobby, and their job is to push information and laws and bills and news to try, to try to make it harder to bring a case.
That's very interesting, right? So there's actually probably a budget to push the idea that you don't have the rights.
Millions upon millions. These are the biggest insurance companies: Chubb, Geico, State Farm, all the ones you see on TV. And those are huge companies with millions, if not billions, of dollars behind them.
Interesting. Very interesting. Okay. One more question. What if you buy products that are defective and it explodes? My question is, if it doesn't do physical damage, is it still personal injury?
Okay, so there's a couple pieces to that question.
Okay.
First of all, there's something called the statute of limitations. So that's another one of the things that, if you want to know whether or not you have a case, that falls under. Statute of limitations means that you have a specific time frame to bring your lawsuit, to commence your lawsuit with the summons and complaint most times.
So if it happened in 1990, I'm out of luck?
So as everything we're discussing, there are differences to that. There are exceptions to the rule, so to speak.
Okay.
For example, there's what's called the CVA, the Child Victims Act, which got rid of for a period of a year and actually got extended for another year because of coronavirus. They got rid of a statute of limitations. So they basically said any child that was sexually molested by anyone, and if they want to sue, we don't care when it happened. If it happened last year, if it happened in 1970, we're getting rid of the statute of limitations for this specific time period so that people can sue because it's so egregious. So that's an example where there isn't a statute.
All right. So for this discussion of statute of limitations, I guess what we're saying is the limit of time when you can bring your case. We're just going to talk about blanket general rules. This does not mean that there aren't exceptions. So we're not going to discourage people. So if you're saying now 3 or 6 years, there may be an exception, right? Like what you just talked about. Right.
So generally for negligence, and this is the law in New York, it's 3 years.
Okay.
Meaning from the date of your injury, you have 3 years. From the date of the car accident, you have 3 years to sue the driver, to sue the building where you tripped at, to sue the store where you bought this product that exploded, et cetera, et cetera. Actually, with the product, that falls under a different umbrella. So to answer another part of that question of whether or not you can represent someone to buy a product. Was that the question?
Yeah, wait, hold on. Let me try. I'm going to try the technology. So bear with me. I'm going to try this. Oh, see, this is amazing. Oh my God.
Great. That's
sorry, that's the wrong comment.
That's my Thank you, Ipal.
No, okay, that was great, but that's the wrong comment. Sorry about that. It works.
Yeah, thank you for asking, but we've already answered it.
Yeah. Wait, hold on. This is it. Oh, now it's cut off.
No, I think I see it. Oh, the whole thing's not there.
Yeah. Well, I mean, it's good now that that we know. All right. So, I mean, it sounds like it's more like of a product liability question a little bit. So let's get back to more of a on track, even though we appreciate it greatly. the question.
So I just want to say, we do have product liability cases. We actually have situations of, things exploding, unfortunately. So that would fall under negligence.
Okay.
And then separately also products liability.
So it's two cases maybe.
Well, they go into the same case, but you allege violations of both negligence language in your summons and complaint and product liability language in your summons and complaint. So that would absolutely be a case. But what you need is an injury. I think in that situation, they said there's no injury.
It says, my question is, if it does not do physical damage, is it still a personal injury?
So I'm assuming when that person says physical damage, they mean there's no personal injury to the person. So maybe something exploded, but your couch got ruined or something like that. So that would be an example. That could still be negligence because your damage is to your couch, but it's not something where a personal injury lawyer would get involved. That's more of a property damage situation. And a lot of times, if someone has a homeowner's insurance, it might fall under that policy and things like that. So in that situation, it wouldn't necessarily be a case. But if the product that you bought at the store, we have cases where a coffee maker exploded.
Mm-hmm.
You go on, you research it online. Turns out this coffee maker's been exploding for the past 4 years. The company's doing nothing to change it. They're putting it in the stream of commerce, right? That's something that you do in law school. They're selling it in the stores, knowing that it could explode, right? So that if there is an injury to someone, then that could potentially be a case.
Very interesting. Okay, that's interesting. Okay, so let's get into, I think, an important part of it, which is damages, right? And I think we will revisit our comment about the verdict there, right? So a personal injury, or I don't know how you want to slice it, or medical malpractice has occurred. What types of categories of damages can a person look to recover?
Okay, so first of all, there has to be an injury to the person, right? So I know we discussed this briefly. There's something that's called no-fault law in New York. No fault.
Mm-hmm. No fault.
That applies to incidences involving the use or operation of a motor vehicle in New York State. A lot of states have no fault, but we're going to talk about New York no fault right now.
Right.
So they have a specific threshold where in order to bring a lawsuit, you have to have what's called a serious injury. Now, that's a term of art. That's something that the Assembly in New York got together and they came up with a specific language that they want to be considered.
Legalese.
Right. So an example. Explain it to us. So a serious injury would be death, dismemberment, disfigurement, a fracture, or a specific time limit of limitation of use of your body part or of limitation of your normal activities like going to work, etc.
Okay.
Usually 90 out of 180 days immediately following the accident.
Okay.
The way no fault works for motor vehicle accidents is they don't care about the fault. Automatically, the insurance company has to pay up to $50,000 for any medical treatment.
Okay. So wait, but hold on. Okay, hold on. Wait. What if I rear-ended someone and I also got injured? Will they pay for my stuff too?
So up to 50, yes, because they don't care about fault. If you injured yourself and what happens is you submit you submit proof. You submit your doctor's bills, your doctor's records. Okay. And even if you're the guilty party, so to speak, you still are entitled to no fault benefits in that situation.
Okay. But then for the victim, they also don't have to worry about proving fault. They still also get up to $50,000 compensation.
So that scenario only applies up to 50. If the person is deservedly to be compensated for more, that's when we come into play.
I see.
That's when you have to initiate a lawsuit.
Okay.
So what this did is kind of get rid of, the quote unquote smaller cases and try to make it so only the quote unquote more serious cases make it into the courthouse.
That makes sense.
So that's an example of injuries in a motor vehicle accident. Mm-hmm. You prove it through medical records. If you have an injury, if you had a surgery, that operative report and all your doctor's visits, that's the proof of your injury.
Okay.
If you get a cast, if you miss work, if you If you submit your tax returns to give them to your attorneys, and eventually the other side attorneys want them. They go through your tax returns. If you're going to claim lost wages, you're going to see what you made last year, what you made the year before, what you're projected to make the next year.
Okay, I see.
Lost earnings.
I see. All right. So let's recap. Let's bring it back, right? So there was a duty, and then the duty was breached by either doing something wrong or not doing something you were supposed to do. Then that caused us damages, injuries, and you briefly mentioned how we can prove it, medical reports, whatnot. I mean, that goes more into, I guess, like, proving it. So now let's say we made this case. So let's say we checked all the boxes.
I just want to add, there's also pain and suffering, which people are entitled to be compensated for, so they don't realize. Literally, you're entitled to be compensated for the pain and suffering of going through whatever the accident was. There's also loss of enjoyment of life. If someone is an avid baseball fan, season tickets to the Yankees, goes to every Yankees game. They get in an accident, they become blind. They could potentially say that they lost the enjoyment of life of watching baseball. Okay.
Wait, so hold on. So you're saying if you have a case and you're successful, you can potentially recover lost wages, loss of enjoyment of life. What was the other one you said? Like something emotional?
Yeah, there's emotional distress. Yep.
Emotional distress. So the fact that you were like stressed or really upset or terrified by the situation, right? What other like financial buckets? I mean, it's interesting because you know what I mean? No one thinks that stress can be equated to money recovery, right? So like, I think it would be interesting for like our listeners to learn, like, what does that mean? Like, okay, so fine, I got into a car accident or whatever, I slipped in some horrific incident, fell off a building. What is this emotional distress and loss of enjoyment of life? And like, what are the sums? I mean, I know you can't tell us exactly, but is it like $1 or is it like $1 to $1 million? What is it?
So that's a great question. That's when experts come into play. A lot of times in these cases, especially the ones that go to trial, which like a lot of our cases do, you have to hire an expert. That means someone with knowledge above a regular person in a specific area. So, for example, one of the experts that we use in a lot of the cases is a life care planner. That person literally meets with the injured party over a course of a long time, reviews their medical records, and puts together a plan of what that person would need medical treatment-wise going forward, medication-wise going forward, care, transportation. This is cases, we deal with a lot of traumatic brain injury cases. That's the type of injury that unfortunately you see happen a lot, where the person is physically okay, but there's an injury in their brain. They can't, or whatever it is, they can't live their day-to-day life normally. So with
this expert, do you get compensation? Can you potentially get compensation for that?
So what happens is the expert puts together a life care plan, which literally shows you every year what charges would be needed for this person going into the future.
Okay.
The judge has a special book which tells them how many years on average someone's going to live. And what we ask the jury based on that and based on the life care plan to compensate that person. And that's just for medical. That's just, that's only for whatever they need to pay for as a result of the accident.
Interesting. So we should be aware of time. It's such an interesting topic. We are at 8:45. I mean, I don't mind going longer because this is exciting stuff. But what kind of numbers, what are like the greatest or the worst verdicts? Like when we're talking about emotional distress, when we're talking about enjoyment of life, like what could those possibly be? Like, because, for example, I say this in employment law, people find it, mind-blowing to find out that emotional distress could be 50 to 500,000. So the fact that, your boss harassed you or called you something racist could actually be worth $500,000 in court. I mean, if it was egregious enough, right? So is there a range that you've seen?
So first of all, it depends on the injury. Every injury is different. Every case is different. You could have the worst injury of all time, but liability is not that good. It's 20% the other side's fault, 80% your fault. So even though you have a very, very serious injury, you're looking at a small percentage of that, right? So every case is different. What we do is we base the numbers we demand on what's happened in the past.
Okay.
This works for two reasons. One is you know, it's depending on the injury, on the fact pattern, on the situation. If the case gets appealed, if the Court of Appeals look at it, they're going to see numbers, you know, that if the numbers are in the range of what's happened in the past under similar circumstances.
It's fair. So it's like fair. And
that's what they consider fair. You know, it really, I can't answer this is worth this, that is worth that. It really depends on the accident. But the guidepost, if you will, is cases in the past. You know, we have left law, and that's called case law values, appellate division case law values. And we're able to see, oh, we're way above it or we're way below it.
I see. So it sounds like if you got a consultation, got all the facts, assessed the case and all the legal weaknesses and strong points, and to that specific consultation, you would be able to assess the value of the case when you weigh all the. I really love that you're not being careless with throwing money and like promising big numbers, because I think it's a much more responsible way to practice, right? Saying like, I really have to look at your case to tell you anything. So I actually really appreciate it. Now I feel like I set you up for a question, but you passed the test. So let's see.
No, you know, the goal for us is to, you know, to get the injured party what they deserve. Every case is different. Right. You know, it's situations where the insurance company is going to try to nickel and dime and give people half of what they deserve, a fourth of what they deserve under the circumstances. And our job is to get people the compensation, you know, that they fully deserve. They're fully entitled to. Right.
And obviously by checking precedent and being well-informed attorney and knowing where their case should be worked. Right?
Like fighting for them, and, you know, fighting for them from the beginning of the case to the trial, fighting for them through the trial. And a lot of times we're fighting for them after the trial as well.
I see. All right, wait, hold on. We've been neglecting our comments a little bit.
No problem.
Let's see. Okay, we already answered that. What happens if I signed a waiver of liability for injury and I get injured? Can I still have a case?
That's another good question. A lot of it depends on the situation. We do see a lot of cases where, for example, you buy a ticket to a ball game, and on the back of it, people don't even realize it's like, you're hit by a ball, you can't sue it.
Right.
So, and as you know, unfortunately, especially in baseball, it's possible to get hit by a stray ball. They put up more netting and everything, but people are still getting hurt. So
right.
It depends on the case. It depends on exactly what happened. But just because you signed a liability waiver does not mean you automatically don't have a case.
So you would also not discourage.
And then this is where a lot of contracts law comes in as well, because, it's a question of whether or not that contract is even enforceable. It depends. A lot of times you have that, people are playing, basketball rec league or like football. A lot of times the leagues don't want to get sued, so they'll have someone, sign some waiver that they put together, the day before. So just because you signed a waiver does not mean you don't have a case.
Okay, that's good.
Circumstances, but that blanket statement, just because you signed a waiver, it does not mean that you don't have a case.
Okay. That's good to know. All right, one more. What is the statute of limitations for medical malpractice if the medical malpractice is discovered 3 years after the incident?
That's another great question. I see that's from my friend Jared. He's an attorney in Boston. Thank you for the question, Jared. Under medical malpractice, I know we didn't really cover that much. There's an exception. Well, usually it's 2.5 years from the last time you treated with the doctor.
Okay.
But there's something called continuing treatment, where even though the negligence happened 5 years ago, but you continue to see this doctor, 5 times a year, it's going the 2.5 years is going to be counted from the last time you saw the doctor. Or when the doctor knew or should have known that there was negligence.
So it extends it. So if you've been treating, then it could extend it, and you may be still in the green light to bring a case. And
that answer is New York. We're just strictly talking New York law. I'm not sure if in Boston that's different, but that's how it is in New York. So just because you think you were a victim of medical malpractice 5 years ago, 3 years ago in this situation, does not mean necessarily you don't have a case. You need to speak to an attorney immediately.
Very interesting. All right, so we've talked about damages. We've talked about, it's like 9 minutes to an hour. So we had a question before, I believe, about, so if a client comes to you, are they responsible for fees? Are they responsible, for paying you? Do they have to have like a savings account to afford your counsel?
Right, another great question. We work on contingency fee. So that means no money up front. from the client. All we need from the client is to sign some paperwork, things that make, what's called a retainer that makes us their attorney, them our client. And then there's no money that needs to be paid. The only way money has to be paid is if there's a recovery.
Okay.
So only if there's a recovery, we, in many instances, our firm, pays all the upfront payment. We pay for all the paperwork. We pay for all the appearances. We pay for things like that. But then it gets deducted at the end should there be a recovery. Now, if there's a recovery at the end, the law firm basically gets a third. The client gets 2/3. The first thing that happens is you deduct the expenses that were fronted in the beginning.
That's right.
From the client's share, any liens. A lot of times there are insurance companies, health insurance companies, they're entitled to a lien. So if you get hit by a car and you end up exhausting your $50,000 in no fault and you have to pay with your own insurance, if you add on $20,000 to that, at the end of the case, your insurance is entitled, if you get compensated, to get $20,000 back.
Sure. Okay. So yeah, right. So there's exceptions of expenses.
After all that, exactly, it's 2/3 go to the client, 1/3 goes to the law firm.
Okay.
That doesn't matter if it settles in the beginning, before it's put in suit, after it's put in suit, before trial, after trial, during trial. It's always a third, 2/3.
I see. Yeah, so that's how we work to an employment law, which means that, the client doesn't have to stress affording an attorney, which I think is a big deterrent to a lot of people. They're like, oh, I'm in so much trouble now. I either don't have a job or I'm injured or whatever it is, cannot afford an attorney. So it's another area of law where you shouldn't be worried about that because the cost would be upfront and be fronted by the law firm, right? And then at the end, if they prevail, then you guys just take a part to recover for your work.
Right, and it's motivation for us as attorneys because we're only getting compensated if we get compensation for our client.
Right. So the interests are aligned for you. The better you do on the case, the better it is for the client. But obviously, you gotta eat too. So the better it is for the firm, which I think makes sense. All right. Well, we have another question about bench trials or whatnot, but let me ask you, like we covered all about this. We're a little short on time. So what is, is there anything else, like an area we missed that we absolutely have to know about?
I want to just drop in just general medical malpractice just to explain.
Okay.
In medical malpractice, the doctor's duty is to act as a reasonable doctor in that community. So there's a threshold where how the doctor, if you have the breach, the causation, and the damages, the duty is for the doctor to act like a regular doctor in their community. So
what do you mean in their community? So you mean like
that's also a term of art, but the way I explain it is if you're getting eye surgery and it's an ophthalmologist doing your surgery, you're comparing them to other you got the surgery in New York City, you're comparing them to other ophthalmologists in New York City. If you're in in a town in on Fire Island, if you're in Seaview and there's an ophthalmologist in Seaview, you're going to compare it to any ophthalmologist. It literally means in the general community.
Interesting. So like if I'm somewhere in a tiny village with one doctor, then I shouldn't expect much of a duty of care. So what you're saying.
The way, right. It's a general statement, but the way to explain it is to bring a medical malpractice case, you have to have an expert doctor in the beginning of the case. Usually you need the expert towards the end. In medical malpractice, you need him or her in the beginning.
Like to prove the issue.
Literally with comments and complaint, which is the paperwork that starts the case. I know we didn't even get into any of what goes into the case. We can do this again. But with the paperwork to start the case, you also need an affidavit from a doctor who's admitted to practice law in the county where you're suing, in the state where you're suing, to say this is negligence. I reviewed the records. This is medical malpractice.
The people that give you these affidavits must be like the worst hated doctors. They must not have any doctor friends, do they?
Well, you find, you can say that about any profession. I know doctors are kind of the ones that, for sure. But, I think that if you get the right expert and they're respected in their field, what they say is correct. So,
of course, right.
They're being swayed. But during trials, that's a big thing that comes up. Each side is making the other side's expert look as if, you know, they're a hired gun or that, you know.
I mean, look, if I was a doctor, I would want to tell the truth. If someone like carved somebody up and left them unable to live their life normally, I would speak up. I don't care if I'm not popular at dinner parties, you know.
Right.
But,
it comes down to whether or not, you know, the doctor was practicing medicine correctly. And if it, you know, if in this, depending on the situation, if it's done incorrectly, then, you know, there should be consequences to that, especially if someone's injured.
Speaking, okay, I'm sorry. This is off topic. We don't have time, but this is like such a bad thing that's happening. Did you hear about the doctor that's cutting out uteruses of immigrant women on the border in detention centers that is not even certified by the board? And like everyone's like, he's not our doctor. We don't even know what kind of doctor he is. And it's literally happening. Like that's, you know, there's like so many victims in that. I'm sure that's a field they will all need attorneys for medical malpractice.
We have cases where a doctor said he did a surgery, but really all he did is open someone up, wait for an hour, close them up, and then submit it to insurance saying he did a surgery. You know?
Wait, what? Wait, what do you mean? So just a doctor just like, okay, cool, I will drink it like a Sprite?
The doctor will write up a whole fake operative report. They'll tell the patient, you know, you did well, surgery went well, this is what I did, etc. And really nothing was done.
Wow, that is shocking.
You know, that's one end of the spectrum. The other end is, you know, leaving a sponge gets left in someone, you know, during surgery. You know, we've seen stents or clips left in people after surgery. You know, it could literally be anything that goes wrong, quote unquote, including prescribing the wrong medications, prescribing the wrong antibiotics, sending a patient home and they should have stayed in the hospital and been observed, things like that.
Wow, that's terrifying. Okay, look, I'll say this thing. Technically, we have 1 minute left. So I don't know if this technology will cut us off at 1 hour. Maybe it will. If it does, we will make a part 2. Don't worry. However, if it doesn't, then I think
let's do another 5-10 minutes. That's fine with me.
Yeah, right. So I mean, unless we do a popular vote and get like more comment engagement, should we keep on going, guys? No, yeah, please vote. Not a joke. No, it's good. But all right, so
vote, guys.
Yeah, no, I don't think anyone is voting. It's fine. Let's not put people on the spot. So look, all right. So medical malpractice, you covered the duty. Fair enough. What I do think what we want to discuss is we wanted to discuss trials, right? So now we talked about having, you know, all the elements. We talked about what kind of things you can recover. And now, you know, you're a trial attorney. So now there is, how does it actually happen? And hold on, let me read you a question.
Sure.
Oh man, what is it? Where is it? Oh, wait, hold on. So, all right, wait.
I see, when is a bench trial preferable to a trial by jury? Is that the one?
Yes.
Yeah, that's a perfect segue into trials. So briefly, cases, they get started. They go through the discovery phase. There's depositions, there's court conferences, there's doctor's appointments.
Wait, what's the discovery phase? There's no way our viewers know this.
So the discovery phase is once the lawsuit is instituted, it's started with what's called usually a summons and complaint or a summons with notice. You basically go into the court. You're under the discretion of the court. So the court gives you conferences, the court gives you dates to show up, dates for things to happen. There's what's called a deposition, where if you're bringing a lawsuit as a plaintiff, you have to sit and give testimony under oath. The attorneys for the entities that you're suing get to hire lawyers, and they get to grill you, you know, ask you questions with a reporter and your attorney sitting next to you about what happened. It gets typed into a little booklet, and it becomes part of the case.
Right. So basically, the discovery case, right, is like exchange of information where you get the meat. Not the meat. That's like a terrible analogy.
No, you're right. It's getting the meat off the bones. Like, for example, it's the paperwork that each side is entitled to. The other side wants to see the medical records of your client. Anything, how it's affecting her, the operative report, the radiology report.
Right. So it's like, so you're under this duty to exchange information, right? Like, I'm just thinking, you know, I'm thinking of our viewer and I'm thinking like, what do they mean? So you bring a case and then you exchange information to kind of like really tease out what the claims are, right? And that's a discovery phase. So both we grill we grill the perpetrator, they grill you as a plaintiff, you see where the truth lies in preparation for trial, right?
Yeah, I think you said you had a deposition today, right, Milana?
Yeah. I'm so tired. No, but it was great. It was great. We were defending. So someone who had sued their previous employer, it was their day today to answer the employer's questions. And her story was, we only bring cases that have merit and that are true. So she just told her truth. It was really good. The reason I'm tired is because we had a translator. So I had to listen from Russian to English to make sure the translation was correct.
Yeah, so you're at a good advantage in that situation where you can actually understand. You can even, if the translator translates something incorrectly, you're able to pick up.
Right, but also you don't want to piss off the translator because then they stop translating.
Yep, I know exactly what you mean.
All right, so discovery. So we went through discovery.
Right, so paperwork gets exchanged, etc. I say I want to see, I find out that the other driver was in a car accident 5 years before doing the same exact thing. I say I want all the documents on that. I want to know what happened, things like that.
So it's like a negligent driver, and like we're gonna get him because he's been bad before.
Exactly. That could show that he's more likely to be. You can't present it for showing that he's going to be more likely, but jurors will think that they're going to be more likely if they did the same thing in the past.
The trial games. This is fascinating. This is like when you watch like really specific lawyer movies. Even as a lawyer, I'm like, oh, this is so good.
Right. So once the discovery phase is done, usually, they're at the end. Sometimes there's a motion for summary judgment. One side asks for the court without a jury, just for the judge, to look through everything in the case and to say it's automatically his fault or it's automatically her fault.
Okay.
So that can happen.
Wait, hold on. Why would this happen though? Like, so, okay, again, we have a lay viewer, right? Like, why would someone bring this motion?
Right. So an example is a pedestrian crossing the street in New York City with the cross light in their favor.
Okay.
They're in the crosswalk and the vehicle is making a left turn and strikes them, right?
Mm-hmm.
You have all those elements. They're in the crosswalk. They had the light. The other car is making a left turn. You can bring what's called a motion for summary judgment for the court to say it's not, for liability purposes, for fault, it's not the pedestrian's fault. It's only the car driver's fault.
Okay.
So in that case, you proceed to a trial only on damages, where the jury, once you pick them and they're sworn in, they don't hear anything about how the accident happened in most instances. Only about the injury, the damages, the surgery, the ambulance, the setting of the wrist in the ER, the screws, the plates, things like that. So
basically, I mean, okay, by the way, like, I'm sorry, but you see how I'm like trying to think like a person who's not a lawyer and like try, because, that's, thank you. I mean, because, in my practice, obviously do some of this, but I'm thinking like, what could, who is watching, not now. So, okay. So what you're saying is when you have teased all the facts out, then you could gather those facts and ask the judge to decide one part of the case, which is saying someone was indeed at fault. And that way you kind of like shorten what you have to bring to the jury, which will be consistent of like normal people to decide. So if you win on law with the judge saying there was liability, somebody was at fault, then your trial gets basically easier. You don't have to win everything. You don't have to win liability, explain to normal people what had happened, right? Because it was decided by a judge. And then you just will focus on, what compensation is, right? That's where we're at.
Exactly. And the reason the reason that's done in our court system is to try to, not overwhelm the court. So if that can be decided beforehand, that gives you a shorter trial. That means you're taking up that space and the time of the judge and the resources.
Right. Because I mean, we haven't talked about this, but the idea of like trial by jury, which I think is pretty unique. I mean, I don't know many other countries that have it. Pretty unique that you have a right to be judged by your peers, right? So they take a cross section of society that represents where you're living, and they will say if it's just or unjust, right? So now you just talked about a technical legal mechanism that can narrow down the issues lay people have to decide. So if by law, like all court and everything, it was clear cut, right? That there was an issue, that there was liability, that somebody was at fault and they do owe you stuff, that way you decided, you make the courts less busy with those decisions, and then you present what the jury can decide to the jury, and it's much less. And obviously, it's good for administrative purposes,
Right.
and it's good for everyone.
And it helps your case. You win on that issue, that one part of your case. You win, or if you lose, the case can get dismissed. You see that happening as well.
Okay.
Where that can, it goes both ways. The other side, the defendants, they also have motions like that to say it's 100% that person's fault for slipping on the banana peel. They should have seen. That banana peel was there. They knew it was there. It was open and obvious. They should have seen it.
This makes me think of Tom and Jerry. So Jerry and Tom were never liable. Okay.
Yeah, exactly.
All right. So
just to answer that bench trial question. So first of all, we usually, and not always, usually would recommend a jury trial. With a jury, it's 6 or 8 people that you chose. They made it through jury selection. You and your opposing counsel, chose through a specific process.
Okay.
Where, it's just a preference. It's not always, because there's also cases where it's better to go in front of a judge, depending on the situation.
Mm-hmm.
If your client is not likable, so to speak, if it's someone who you think 6, 10, 12 people wouldn't like them, maybe it's better to go in front. I'm saying that's a decision that has to be made strategically.
Okay.
There are courts and court systems where you only have a bench trial. For example, if you're suing the state of New York in the Court of Claims, they don't do juries. You have only a bench trial.
Interesting.
So, for example, if you're a bike rider and you're riding on some state highway and you fall into a pothole on a state highway and you sue the state of New York for their negligent maintenance of the roadway, you're going to the Court of Claims. You have to actually file what's called a claim. It's not even called a lawsuit. It's called a claim.
Interesting. All right. So basically, sometimes you may have an ability to bring to a jury. Sometimes you may not. But it sounds like juries, you find them preferable because they have empathy for your injuries.
Yeah, but that's just a general statement. It depends on the judge. It depends on the county. It depends on your client. It depends on the injury. It depends on all those things. So it really depends. But usually a jury trial is the optimal option. Interesting.
Wait, hold on. Let me just make sure I didn't miss any. Wait. Okay. What determines how much I would receive after a verdict, and how much does my attorney get? Okay, fine. All right, just kidding.
What happens is that, the jury or the judge gives a verdict after everything. There's opening statements in a trial. There's testimony from witnesses, parties, experts. There's cross-examination where I ask questions of the other side's expert. Then there's closing arguments.
Mm-hmm.
Then there's the jury deliberating. They come back with their verdict. And there's a specific jury sheet that you put together with your adversary and the judge of specific questions for the jury to answer.
Mm-hmm.
And if they make it through the liability questions and they put liability on the other side, they get the damages. They vote among each other and write in a number of what they think the person deserves. And that's based on the evidence I presented during the trial.
Very interesting. Wait, so how long can a trial typically last?
Again, it depends. I've second sat one of my bosses, the trial attorney at our firm, Jeff Korek. I've second sat him on literally a 3-month trial, including jury selection and everything.
No.
And I've done myself, a quicker trial of a week of, starting on a Monday, being done by Friday.
Sounds like you're efficient. They should promote you.
It really depends on the number of parties, the number of experts, the number of witnesses, how long it's going to take you to pick the jury. And anything, it can be anywhere from a day or 2 to a month. So, yeah,
I hear you. So I was going to say, one of the things, so I'm half Russian, I'm Serbian. When I was growing up in Russia at the time, before I had this dream of being an attorney and making, world a better place through law, I remember when I was like 6 or 8 years old, listening to the news saying, in America, a woman who was 80 years old spilled hot boiling coffee on her groin and got $80 or $50 million. And I remember how everyone was like, wait, what? And it was because of enjoyment of life and inability to have sex. And I remember this, right? So that must go to juries. Is there a limit how much jury can award in an injury if it's like something egregious and the conduct was really horrible, right? Like either McDonald's should have really known. After this, I think McDonald's lowered, it was a McDonald's case. They lowered the temperature of their coffees, and they put disclaimers and whatever it is. But I guess what I'm getting at it is that if we have a perpetrator who was like either super drunk or like drunk doing surgery or was like egregious and terrible character, can a jury award you like millions of dollars in damages?
So the answer to that is yes. But what you don't hear is a lot of times what could happen, it would be an appeal where the other side appeals it. They say, this is way too high. This is egregious. This is, triple what other cases in the past have been compensated. So what happens is if the other side feels that way, they'll appeal the verdict. So, if you broke a pinky, but you had the best trial lawyer in the world and they got you, $100 million from a jury, the other side is going to appeal that. And the court in the appellate division or the court of appeals is going to say, yeah, a broken pinky is now worth $100 million. She's entitled to whatever it is, $100,000.
So you're saying those people that we see in newspapers getting 80, 50, 10 million, they don't always get the money.
What you don't hear is 5 years later, once the appeal was decided, that they ended up getting much less. Exactly. A lot of times what happens is while the appeal is pending, the sides could settle, right? So not at that maximum amount, but not at that low amount. It could settle. A case can settle at literally any time.
Interesting. So you're saying, like, I won the trial, I got $80 million, and then you appealed. And as my lawyer, let's say, that 80 million was too much. So you can settle basically like saying, okay, let's not wait for the appeal. Let's just like decide how much we take. You could say, just take 40 million or 3 million or 5 million, but it's in your pocket today, 5 years later, and you have it, right? Right.
So as plaintiff's attorney, we would appeal. I wouldn't appeal with a high verdict. That would be the defense attorney's side. That's the defendant that would appeal. An example of when your plaintiff's attorney would appeal is if a judge does something wrong during a case, or one of the attorneys does something wrong, showed a picture to the jury they weren't supposed to, said something about a plaintiff that they weren't supposed to say, then that could lead to what's called a mistrial or an appeal that's where a situation where our side would appeal it and say, no, this is
right. So both sides can appeal.
Exactly.
Very interesting. A fun fact, I teach trial ad. I have taught trial ad last semester at Fordham Law.
Oh, that's awesome. You could have me in. I'll teach one a class or something.
I know. I haven't signed up this year because I have so much going on, but maybe for next semester, I would love to do it. And then I think my students can really learn from you because you actually do a lot more trials than I do, because most, like 95% of our cases, 98% of our cases settle. So this is exciting. All right.
So as you know, law is, you're always learning. I don't pretend to know everything. I don't pretend to always have the right answer. We're always learning. We're seeing something new every day.
But that means you're a good lawyer. You know what I mean? Like when I hear people that are like, oh, it's definitely this, I'm like, it definitely cannot just be this because you can't know. Like there's so many variables. So, honestly, look, it wasn't like it wasn't by chance that, I asked you to do this, but because, we've worked together before and I've seen how detailed you were and how meticulous you were and how good you were with clients. Because we've sat on the same intake and stuff like this, but it makes me even happier having done this conversation because I see, that it's a practice of law, like the same way I know it's a practice of law. Not all lawyers know that, like meaning a practice, meaning you learn as you practice and you go and everything is individual and it takes preparation and learning and researching to really get to the right answer. It's never like billboard advertising. We will for sure do this for you when it's empty words and waste of time for clients, right? Exactly. So it's like responsible practice of law for the good of the people, which I'm glad we're affiliated in this.
And Milana, I want to compliment you as well. I've been in your office. I've seen you with your clients, and I want to commend you as well. I see the support and trust that your clients have in you, and constantly looking for a way to help your client. That's what we do. We help clients. And, I want to commend you as well. I've sat in your office with you. I know how you do it. So thank you again for having me on.
Thank you. Yeah, no, absolutely. I think when you do law for the right reasons, it can be such a powerful thing that gives to the clients the right examples, and kind of tips the scales back, right? Because lay people, they could be amazing at everything in life, but we can help them protect the rights that they have in situations that are difficult,
Absolutely.
So, yeah. Well, so listen, this was great. It was definitely not an hour, but I think we covered a lot. I honestly think you should definitely come back for like series 2 and 3.
We can do another one about just the trial, another one about just the case from beginning to end. We can figure something out.
Yeah, totally. We should. I think it's a good thing, when you're like, wow, we have so much more to talk about. It's a good thing. So thank you everyone for watching us. This was really, really good. Avi, thank you for your time. I think let's conclude this, but hopefully if I did the titles correctly in this technology, your email for questions will be listed in the description. So if you have any questions, please contact Avi about any medical malpractice or personal injury, or just reach out to me and I will connect you with him. And yeah, hopefully we'll do another one soon.
Thank you for having me, Milana, and thank you everyone for coming. We really appreciate it.
Yeah, thank you so much. This was great. All right, bye everyone.
Have a great night, everybody.